Now, what's the plan that we've been operating under to date? There's a number of different plans. There's the county general plan, there's the North Area plan, which is just over here. But in the coastal zone, the plan has been the 1986 land use plan. And the 1986 land use plan was adopted by the Board of Supervisors and the California Coastal Commission. The difference between a land use plan and an LCP, a local coastal program, is a land use plan is sort of an advisory document. When the LCP is passed, and it's being sent up to the California Coastal Commission, the Coastal Commission then gets to review it, and they have suggested modifications, and it gets sent back down to the Board of Supervisors for final adoption, and then becomes the law. Now, let's be clear, we want an LCP. What a local coastal program does is it takes this dysfunctional process we have right now, where if you want to have a permit, to put in a vineyard, to put in an orchard, to build a house, to build a cattle pen, a barn, whatever. And remember that definition of development is extremely broad. You have to go to the County of Los Angeles, you have to get what's called an approval in concept. It takes a long period of time. Then you have to go to the California Coastal Commission, you deal with a whole different bureaucracy. You spend about another year, you get your coastal development permit, and then you can go to the county and you can get your building permits and your development permits. When we have an LCP, a local coastal program, it's a one-stop shop. It vests the permitting authority of the county to issue coastal development permits. That's good. In fact, the Coastal Act, which was passed in 1976, said every single LCP would be adopted in the state of California by 1981. So we're a little bit behind schedule. Now, the problem is that the devil's in the details, and there's some really good things in this LCP, but there's some real poison pills. And I'm going to talk about that in a second. But it usually takes the California Coastal Commission about a year to a year and 3 months. That's how much time they're allowed under the Coastal Act to review these LCPs. The Board of Supervisors just approved this LCP, sent it to the Coastal Commission, and they're having the hearing in April. So the reason for that is because the Coastal Commission staff has been working with the county staff to draft this plan. The Board of Supervisors released it. They had no additional workshops. There was 800 to 1,000 new pages of documents from the one that they had tentatively approved in 2007. And in 30 days, they approved it, and they're ramrodding it through. Now, to date, what you've been operating under is the 1986 land use plan. And the 1986 land use plan has policies in it as well that pertain to agriculture. 266 and 267 provide the strongest encouragement. This is what the government's supposed to do. Provide the strongest encouragement for agriculture. 266, encourage agricultural uses in non-urban areas as long as they remain economically viable. 267, encourage agricultural uses with limited land requirements such as greenhouses and nurseries. So fast forward to 2014, right now. Local coastal program is sitting right here. What does it say? CO-102, new crop, orchard, vineyard, or other agricultural uses is prohibited. Period. You are not allowed to process a permit. You are not allowed to farm on your land at all. Now, do you remember those policies I told you about the Coastal Act? That agriculture is a priority use. That LCP is supposed to reflect, is supposed to promote the Coastal Act. Oh wait, there's another part of it. Existing legally established agricultural uses shall be allowed to continue. I think that's extremely magnanimous on their part. So if you have a permit, if you are already established, you're probably okay. And that would be me. That would be some of the others. So, to be clear about a couple things, by the way. These things, rightfully so, tend to get very emotionally supercharged. I don't think that our supervisors are enemy in regards to agriculture. In fact, what he said at the hearing when I protested that they were eliminating agriculture was that he was in favor of vineyards, he was in favor of orchards, he was in favor of agricultural production in the Santa Monica Mountains, but we'll never get it approved. Why? Well, I think he's engaged in a classic mistake. His staff talked to the Coastal Commission staff. And it's absolutely true that the Coastal Commission staff is vehemently opposed to the clearance of chaparral for agricultural purposes. In fact, in 2007, you heard me refer that to that before, the Board of Supervisors did pass an LCP. It was very different than this. It had 35 public workshops in a planning commission hearing, and the Board of Supervisors approved it, and they submitted it to the Coastal Commission, and then Peter Douglas, who was the past executive director of the Coastal Commission, he's since passed on, both spiritually and physically, as well as no longer being the executive director. He took the LCP, and he said, this is dead on arrival. It's dead on arrival. Now, I've represented probably over 1,000 projects in the Santa Monica Mountains over the last 25 years. If I tucked my tail and ran every time the coastal staff said they weren't going to support one of my clients' applications, I might as well pack it up and find something else to do. And I'm having a success rate of something like 98% in front of the California Coastal Commission. But what they did is they said, oh, we're sorry, what can we do about this? So their staff at the Department of Regional Planning and his deputies talked to the Coastal Commission staff, and this is absolutely true. This is what the Coastal Commission staff wants to see. They do not want to see agriculture. If it's going to result in the removal of any native vegetation, and we should probably talk about that for a moment. Up until 2002, native vegetation, do you understand that the chaparral that we have here, and I don't know anybody that's cavalier about the environment, most importantly, farmers. I'm a farmer. I planted my vineyard with my own two hands. And I don't know anybody that works harder in maintaining the soils and being good stewards to nurture the land than farmers. In fact, in no small part, the environmental movement started with agricultural interests. They truly want to protect the land. But the Coastal Commission staff in 2002 realized also for many decades they permitted, I'm looking around the room, I see some property owners in here that have tens of acres or over 100 acres of permitted orchards and vineyards. And for a number of you, I got the permits, I know this. If you take a look around you right now, beautiful, beautiful Rosenthal estate here in Newton Canyon. Okay, that's all legally permitted. George is a client of mine. Sellers are here. They're mostly outside of the coastal zone. But look around some of the others. Hirsch over here on the hillside, that's another client of mine. That vineyard, that's outside of the coastal zone. My vineyard is inside the coastal zone. It was approved by the Coastal Commission. There's a piece of property, several. There's one on Encinal Canyon that has something like 100 acres of approved, coastal approved orchard. What happened? Well, in 2002, the city of Malibu, the legislature passed a law and gave the Coastal Commission unilateral authority to approve a local coastal program. Remember the process I told you, the way that it works? The local jurisdiction puts the plan together, they send it to the Coastal Commission, who chews on it, they send it back, and then it gets approved. For the first time, the city of Malibu had the somewhat dubious honor of having that all turned upside down. Why? Because some elected officials got tired of property owners in Malibu calling them up and saying, do you have any idea what the Coastal Commission is trying to do to me on my project? And they said, the hell with this, we're sick of it. Get your LCP approved. They passed a law, they gave the Coastal Commission complete unbridled authority, and so they got to write the plan that they had always hoped to get, the staff, and never were able to do with because they had to deal with the local jurisdiction. And for the first time, the Coastal Commission came up with this concept which we call Global ESHA. What is ESHA? It's another one of those planner abbreviations. It stands for Environmentally Sensitive Habitat Area. Now, before that, all the ESHA in the coastal zone of California was about 1%. And it's a thing that every person in this room would say, yeah, absolutely, that's ESHA. You're not supposed to do anything in ESHA. You're not supposed to touch it. You're not allowed to develop it except for what's called resource-dependent uses, which is a trail. And with just a couple exceptions, all the ESHA in the state of California was stream bottoms and wetlands. All this upland chaparral here is the most common biome in the state of California. There's more chaparral than anything else. And the vast majority of it is owned by the government. In fact, here in our mountains, it's getting up towards 60% of the land owned by the government. Now, ESHA is supposed to be especially rare or unique plants, animals, or species, like the bottom of a stream. Keep the heck out of it, okay? Don't build in there. Well, they started calling everything ESHA. And how did they do that? This most common biome, they said, well, when you think about things globally, only 6% of the world's biome is chaparral. Coastal California, southeastern Australia, South Africa, and the Mediterranean. So on a global scale, this ESHA is especially rare and unique, the chaparral. So now, everything is ESHA. And so when they call everything ESHA, they're then able to say, you can't build in it, you can't put a vineyard in, you can't have an orchard. Now that's what they did down in Malibu. This is really important. I hope I'm not getting too academic and legal here. It's really important for what we're talking about today. The reason is, on a case-by-case basis, after that was pounded down the throat of the city of Malibu, just north of the boundary on that two-step process, where you go to the county, you get the approval and concept, and then you go to the Coastal Commission. Let's say you're one of my clients, you come and you hire me, you say, Don, I want to put in a house, and I want to have a vineyard around it. It's okay. I also give you the bad news, but we go to the Coastal Commission. What's the bad news? Without any legislative act whatsoever, the bureaucracy, being the California Coastal Commission, started calling everything north of the city boundary, here in our mountains, ESHA. All the chaparral started calling it ESHA, and started telling you, you can't do anything with it. Now, there's still the federal Constitution, and there's still the Fifth Amendment, and if they don't let you build at least a house, and that was a very important land use case of the Supreme Court called Lucas, if they don't let you build a house, they've taken your property and they got to stroke you a check and they have to buy your land. So, okay, we'll let you build a house, but we're not going to let you build anything else, just a house. And so if you've seen any vineyards or orchards subsequent to, say, 2003 up here in the mountains, one of two things has happened. Either they allowed the vineyard or the orchard within the fuel modification zone around the house, about 100 feet out from the house, or it's bootleg. It's illegal. And I've had a lot of people come into my office over the last 10, 15 years, seriously upset because the Coastal Commission has opened up an enforcement action against them because they cleared the brush on the property, they put in a vineyard, put in an orchard, and I'm pretty aggressive and I think we're pretty good at what we do, but I have to tell them, don't bother fighting it. We're going to have to go to the Coastal Commission and we're going to have to process a restoration plan. It's tragic. Now, that's the mindset that the Coastal Commission staff convey to the county staff. But this is very different. We actually have a good opportunity here for two good reasons. One, it's never been the law. It's never been the Coastal Act. It's been the interpretation of the Coastal Act on a case-by-case basis. How they pick off individual property owners. Again, you hire me, you want to get a house, you want to have a vineyard. I bring back the news to you. They say, do you want them to try and deny you? Or do you want to get your house? Because staff will try to get it denied. And previously, this is really important, previously the Coastal Commission would have supported staff's denial of your vineyard or your orchard. And so, of course, in case after case after case, my clients and other people have said, we'll drop the vineyard, we'll drop the orchard, we'll get rid of the livestock production area. Just please, pretty please, let me have my house. Now, this is a plan. This is trying to nail that down and make it permanent, make it the law. And oh yeah, by the way, irrespective of the fact that the Coastal Act itself specifies that they will promote agriculture, if they pass this LCP and it is not successfully litigated in court, LCPs can be more restrictive than the Coastal Act itself. We're this close to having it forever slip away from us. There will never be a new vineyard, a new orchard, or a new organic farm in the Santa Monica Mountains. Make no mistake,